Time now to answer some of your legal questions and return to Fox 26 Senior Legal Analyst Chris Tritico for the answers. We're going to begin the questioning from Deborah, who writes, "My child's dad and I both live in Texas. We have shared custody. He pays child support monthly. I want to relocate to another state. The custody order has geographic limitations. I have received a job offer in another state and have to leave soon. The custody order says I just have to give him and the court a 90-day notice. Does that mean I can leave Texas with my child? After or before notice? Do I have to give the court and my child's father notice of my new relocation? I do not want to go to court. He signed and I signed. Also, what happens if I decide to take him off child support? Will this be a better option for me or a huge issue?"
So I haven't seen the order, but generally if it has a geographic limitation, you can't just leave. You're going to have to go back to court to get that resolved. Most divorce decrees allow the parties, the mother and the father, to make agreements outside of court if you can work that out. But geographic limitations generally have to be ruled on by the court. Most parties are not going to agree to allow, a father's not going to agree to let you take their child out of state in most circumstances. Just saying I don't want him to pay child support anymore is not going to relinquish his parental rights to see his children. So that's just not going to be a good option for you. Sit down and talk with your ex-spouse and see if you can work this out. But typically speaking, you're going to end up back in court to get this resolved. Good luck.
Our next question comes from Ruben, who writes, "My son was involved in a non-at-fault car accident in April. He only received some bumps and bruises, but the car was a total loss. The person responsible for the accident was ticketed and provided an insurance card. We got a lawyer to help with the claim for the vehicle damage and some medical bills. The lawyer stated that the insurance was indeed valid, but the vehicle was sold to the individual who caused the accident. The prior owner never took it off the insurance. My son's car was paid in cash and only had liability insurance, so there is no coverage for the claims. Our lawyer is asking if we have medical coverage on our auto policy so that we may put a claim. We have a total loss of a vehicle and some medical expenses that are not handled yet. What could be our next course of action?"
What your lawyer's asking you about on the second part of your question is, do you have PIP or personal injury protection coverage on your policy? It's no fault insurance if you have it. Most policies come with it. You have to specifically reject it to get it off your policy. If you have it, make that claim. It's no fault on you and it does not raise your rates. They will pay your medical bills immediately upon turning those bills over. There's no reason not to make that claim. Now, with respect to your original claim, the fact that the car was sold, in my view, does not change the fact that it was still insured. And it was the policy had not been canceled on that car. That insurance company is going to have to cover that claim, in my view. Your lawyer should be pressing that and probably is. Talk with your lawyer and see what's going on. Good luck.
Our final question comes from Maurice, who writes, "We moved out our home in January and have yet to receive our deposit. The owner has a property management company to lease us the home. They have our new address. The owner has yet to send us an itemized deduction, nor the reason why we didn't receive our deposit back. What can we do?"
So under Texas law, the property code gives the property owner 30 days to send you either your deposit back or an itemized list of why you didn't get your deposit back and the difference. If they don't do that, then you can sue them in justice court and get 3 times the amount of your deposit plus attorney's fees for their failure to follow the law. So go to the justice court closest to where the apartment complex is that you lived in, and they will help you fill out the original petition and sue them for the deposit, 3 times the amount of the deposit, and put in there you want your attorney's fees even though you don't have a lawyer, because Texas law says if you later have to hire a lawyer, you have to have originally asked for your attorney's fees. So just sue them for it, and you're going to get your money. They'll probably just send you a check as soon as they get served. Good luck.
Always great responses
Thank you.
to some complicated questions.
Thank you.
Now, if you would like to send us your legal questions, just go to our website, fox26houston.com. You can find Chris's segments under the Morning News tab. And as always, for any specific information and advice, you should contact an attorney of your choice.